My name is David Taylor. I'm an accredited specialist in employment and industrial law, and I'm going to talk about the underpayment of wages and entitlements. Most people work in order to be paid, and a key reason they seek legal assistance is when they haven't been paid what they're entitled to. The first step in considering whether or not there's been an underpayment is to work out what a person was entitled to be paid. There are a number of sources of that entitlement, and they include a contract of employment, which isn't necessarily in writing, whether or not there was an award that covered a person, whether there was an enterprise agreement that covered a person, and the provisions of various statutory entitlements, particularly the National Employment Standards under the Fair Work Act and the superannuation guarantee. There's also a number of other factors that need to be considered in working out what underpayment may exist. This includes issues such as whether or not the person was an employee or an independent contractor, whether the person was a permanent employee or a casual employee, what classification the person was if they're covered by an award or an enterprise agreement, whether there was a bonus or commission scheme in place that required the payment of monies that haven't been paid. Each of those things really turns on the facts and involves a detailed assessment of the history. Once there's been an examination of these matters, and if there's a conclusion that there seems to be an underpayment, the next step is generally to write a letter of demand to the employer. This letter will set out the basis of the underpayment and seek to have it remedied by payment of what's outstanding. In the event that doesn't resolve the matter, and quite often it does, the next step is to commence proceedings in a court. The court proceedings will set out in some detail the nature of the underpayment and try to quantify as best able the amount of the underpayment. The employer will then have an opportunity to respond and indicate why they say there isn't an underpayment. And as is normal in court proceedings, there'll then be an opportunity to prepare evidence, which is often done in affidavit form, which is sworn statements, before the final hearing. The court will also generally order that there be a compulsory mediation. This is an attempt to negotiate a settlement of the matter where the parties meet and, without prejudice basis, try to discuss a settlement where there can be a resolution so that there doesn't need to be a final hearing. If there can't be a negotiated settlement, a judge will determine the matter. The judge will consider all of the evidence and the legal arguments made and will reach a conclusion as to whether there's been an underpayment. Normally, if there has been an underpayment, the judge will order that underpayment be remedied and may also make an order for penalties, that is, fines, on the person responsible for the underpayment. You can also get other payments such as interest, and if there is other loss that's occurred as a result of the underpayment, compensation for that loss. It generally takes about 12 months from the commencement of the proceedings for the final hearing to occur, and then another 3 or 4 months for the judgment to be published by the court.